Any real estate transaction comes with a significant amount of paperwork: contracts, disclosures, addendums, and state-required forms. We keep the process as simple as possible using the latest technology for e-signature and transaction management. But I want to walk you through what you will be signing so nothing feels unfamiliar when it lands in your inbox. Knowing what each document is and why it exists allows us to move quickly when it is time to sign. The mandatory disclosure. This is the first document you will receive from your team member. It is required by the state and identifies the type of agency relationship we are practicing. In most cases, we are acting as your designated seller's agent, meaning our fiduciary duty runs entirely to you once a listing agreement is executed. The listing contract. This is the governing document of our working relationship. It defines the time frame of our agreement, typically 6 months, our roles and responsibilities, your responsibilities as the seller, our compensation structure, and any other stipulations relevant to how we will work together. Read it carefully. Ask questions. This document matters. The concrete foundation disclosure. Certain homes in Massachusetts were built with a concrete foundation containing a mineral called pieratite. Over decades, exposure to moisture causes this material to oxidize and the foundation to crack and deteriorate. This disclosure is required so that buyers are aware of whether the issue has been identified at your property. Your team member will walk you through this form. The mandatory home inspection disclosure. Effective October 15, 2025, Massachusetts law preserves every buyer's right to a home inspection. This disclosure informs the seller of that law and of your legal obligation under Chapter 93A. A seller may not knowingly accept an offer from a buyer who intends to waive their right to an inspection. Violations carry substantial penalties. This form ensures you understand that obligation before your home goes to market. The lead paint notification. For homes built prior to 1978, we are required to provide a property transfer lead paint notification. This document discloses whether there is any known presence of lead paint within the property. Lead paint poses serious health risks, particularly to children under the age of 6. The buyer will also sign and return this form to us at the time of an offer, as it is required by state and federal law. The affiliated business disclosure. This is a straightforward disclosure acknowledging that Coldwell Banker Realty may have business relationships with certain settlement service providers. You are never required to use any of those providers. This form simply ensures you are aware those relationships exist. Third-party resources form. This form identifies outside resources that may be available to you as part of the transaction process. Your team member will explain any that are relevant to your situation. Statement of seller's property condition. This is one of the more important forms in the package, and one that deserves a direct conversation. We are required to present this form to you. It gives you the opportunity to disclose known defects and conditions of the property in writing. Our recommendation is to speak with your real estate attorney before deciding whether to complete it. Attorneys have differing opinions on this form, and roughly half of sellers choose not to fill it out. What does not change, regardless of your decision, is this. If you are aware of a defect or material issue with the property, we are obligated to disclose it to prospective buyers. A written form is not the only mechanism for disclosure, but it is one of them. The form declining to complete the property condition disclosure. If you choose not to complete the statement of seller's property condition, there is a corresponding form acknowledging that decision. We will present both to you together. Subject to suitable housing contingency. If you need to find and secure your next home before you can close on the sale of your current one, this addendum may be incorporated into your listing strategy. It allows us to structure an accepted offer with a contingency tied to your ability to identify suitable replacement housing. Your team member will discuss whether this applies to your situation. Designated agency and consent to dual agency. Massachusetts law requires written consent for designated agency. These forms identify which agent within our brokerage is specifically designated to represent you. In the event that our brokerage also represents the buyer in the same transaction, a dual agency situation arises. Dual agency requires your informed written consent and changes the nature of our representation. This is explained in full in the forms, and your team member will walk you through it clearly. Wire fraud advisory. Wire fraud targeting real estate transactions has increased significantly in recent years. This advisory is not a formality. It is a serious warning about a real risk. Before wiring any funds at any point in this transaction, You should independently verify the wire instructions by calling a known phone number for the receiving party. Never rely solely on instructions received by email. Your team member will reinforce this throughout the process. Pre-listing marketing addendum and delayed listing forms. In some cases, we begin marketing your home before it is formally entered into the MLS. A pre-listing marketing addendum documents your consent to that activity. A delayed listing form is used when your home is not entered into the MLS immediately upon signing. MLS rules exist to protect fair market access, and these forms ensure we are operating in full compliance while giving us the flexibility to prepare your listing properly before it goes live to the public. In my opinion, only by exposing your home to the entire market ensures the opportunity for the best possible offer. That strategy involves have as many home buyers and their agents through your listing as possible. Other documents. Depending on your specific property and circumstances, additional forms may be required. These can include a Title V disclosure, if your property has a septic system, an inclusions and exclusions worksheet clarifying what personal property stays with the home and what leaves with you, confidentiality agreements, and other addendums as the transaction requires. Your team member will flag anything relevant to your situation as it arises. The goal of this video is simple. When these documents arrive, you should recognize every one of them, understand why it exists, and be ready to sign without hesitation. The faster we move through paperwork, the faster we can focus on getting your home sold.